Welcome to the Power Exit Podcast. This show is dedicated to business owners who want to scale up, plan smarter, and prepare for the ultimate exit. We'll talk with M&A experts and owners who've been through the process to provide actionable advice so that you can sell your business on your terms and without regret. I'm John Marsh. Join me as we prepare to take control of your exit. Rob, thank you for being here on the Power Exit Podcast.
Yeah, good morning.
I'm excited about this one. We've had some former clients, but this is the first kind of other professional who serves and works on M&A deals. So I'm excited to pick your brain and hopefully provide some value to the listener on how to do a transaction under the power exit without regret and on your terms. So tell us a little bit of background. You've got an interesting story. I would love to hear, or the listener would love to hear about your background and how you got to where you are today.
Yeah, grew up in Michigan, and I always wanted to be in the military. So I went to a military school. I graduated 3 months before September 11th as an infantry officer in the Army. And obviously September 11th happened, and within 9 months I was in combat. So I was an airborne ranger. I served multiple overseas tours in Iraq and Afghanistan. And I quickly decided that that probably wasn't going to be what I was going to do for the rest of my life. At the time, they were predicting that the war in the Middle East would last a long time. And I just had a sense that I'd probably do something else. I would serve my time, but probably do something else. So I began to just think about my future after the military. I didn't really have a plan. I was going to be a career military person. And I thought, law is, I don't know why I thought this, but I thought law is safe. It's a good degree to have. And I'm not sure what I would do with it, but I think I want to go to law school. I applied to law school. I went to the University of Georgia, and I decided I didn't want to litigate. I didn't want to do family law. I didn't really want to deal, given my background in combat, I really didn't want to deal with things that were contentious. So I that kind of narrowed my field in law school, and I really began to look at business law, in particular corporate work, and I thought I might carve out a career as an M&A attorney. I graduated from law school in the middle of the 2009 economic recession. So if you're following the timeline here, I don't necessarily have impeccable timing. If there's a hard way to do things, I typically choose that. And that's been fairly consistent in my career.
Yeah. That's awesome. Now, a couple of things I want to drill down on. One, you chose something not contentious, but you ended up in M&A law.
Right.
We can as professionals in the space, we know that they can be contentious.
That's right.
But your story actually goes back further. If I'm remembering correctly, since you were a little boy, you wanted to be a military.
That's right.
Military. Is that
That's
right?
right. It was I visited West Point as an 8-year-old kid. And I had a very strong sense. It just, something came over me. I said, I'm going to go to school here. I'm going to become an infantry officer, and I'm going to lead soldiers in combat as an 8-year-old. And that's exactly what I did. I also visited Georgia as a 13-year-old, and I said, I think I'm going to marry a Georgia girl. And I did.
That's great.
I'm not real good at predicting the future, but in respect to those two things, I knew at an early age. Yeah.
Well, that's one thing I admire about you. You set goals and you achieve them. So good for you. All right. So, obviously the goal of this podcast is to provide some value to those folks who are considering a transaction. So, I'm talking to folks all the time who have never done this. Maybe we'll do this one time in their life, and they don't understand, or we have to educate about the role of an M&A specific attorney, someone who does deals. And they think, hey, I've got a great person who's been my attorney for years, who's worked on a variety of different things. Oftentimes that's not a good fit for what we do.
Right.
Why is that? Kind of tell the listener why it's important to have someone who specifically serves business owners going through a transaction.
Yeah. So I think this is a broader paradigm that just needs to be spoken into the conversation, right? Business owners, my experience of my clients is they are very good at what they do. But doing a business deal, selling a company or buying a company is unlike anything that most business owners have ever seen or have ever experienced. And you can't just pick it up. One of the things I love about clients is many of them started from nothing. They bootstrapped. They had an idea or they took over a family business. Whatever their story is, they were gritty, they were problem solvers, they worked hard, and they've consistently made good choices that have led them to the place where they can even consider an exit. That makes them a very dynamic individual who, in their mind at least, I can do most things that you present me with. The problem with that is it would be like you being a native English speaker, and I walked up and I handed you a piece of paper that had Chinese written on it with no training. And I said, "Can you please read this for me?" That's kind of what doing a deal is like. So we have to shift our mind, and it's a hard thing for business owners to do. We have to shift our mind to the stark reality that you've never seen anything like this, and you're going to actually go through the entire process and still not understand what you just went through. If I'm being honest, right? That's not a scary thing. But it does reinforce the idea that we have to have people who are trained professionals in this space. There's nothing incredibly great about me except for the fact that I have 15 years of experience doing this specific work at the highest levels, right? I've done billion-dollar deals. I've done million-dollar deals. I've worked with private equity. I've worked for strategic acquirers. We know deals backwards and forward. We speak deal. And deal is a very different language than what most people are used to.
Yeah.
That's the advantage that having an M&A specific advisor on your legal team adds to your deal.
Yeah, and we'll come back to that later. We want to talk about some of the pitfalls that come up in these transactions. And I think to your point, if someone's not versed in those or identifying those or knows how to cross those inflection points, it's important to have somebody who does what you do.
Right.
So at what point should a business owner consider hiring an M&A attorney when they're going through this process?
It depends. I prefer to be engaged when someone is awakened to the idea that they are going to exit their business. And the reality is this: everybody exits their business. You either exit on terms that you want to exit on, or you exit on terms that the market or life causes you to exit on. We like to work with clients who say, "You know what? I'm going to exit. It's probably not going to be on the timeline or even in the way in which I'm anticipating, but I know that I need to be as smart about exiting my business as I was about starting it and growing it and building it."
Yeah.
So we like to be involved, ideally 3 to 5 years out. I would say that's rare.
Yep.
But I do have those clients, and we're working with them now. It's not uncommon for us to be involved when somebody receives an LOI on an unsolicited offer. Or maybe they're even in a deal process working with somebody like you, and they just don't have an M&A lawyer. We might get involved then.
Yeah.
I love to be involved when we're doing a structured sale and we're going to engage a banker or an M&A advisor like yourself. I love to be involved even before you're involved if I can be, but oftentimes you and I would become involved around the same time.
Yeah, no, that's right. We when someone engages us, right, we who's the team? Who's on the team? And selfishly, we want to help build that team. We know there are specific M&A attorneys we've worked together before who know how to get deals done. The listener has heard me say landlords and attorneys kill deals, and when you're not doing a deal with a specific professional who's specific to M&A, that's a hard thing. You also mentioned something about time and external factors dictating a transaction.
Right.
And, I say often time kills deals.
Yeah.
That's number one, but time is on your side until it's not, right? Until, God forbid, you lose a big customer or your health deteriorates, then you're not in control. So I love the fact that I agree with you that someone should be hired like you years in advance. And again, we'll talk about that later on what that means. But let's turn our attention to, and this kind of goes back to what we were talking about a minute ago, is what are the common legal pitfalls in a transaction that you see? Um, and maybe caveat that with how you are able to, or an MA specific attorney is able to identify those.
Yeah. Um, the level of due diligence that is done when a company is being acquired depends on the size of the business, depends on its complexity, depends on the buyer, depends on a lot of different things. But I've never had a client say, "Man, that wasn't that bad in terms of diligence," regardless of the deal size. The problem with doing diligence once you've signed a letter of intent and you are engaged in the sales process is this: the price is fixed. So you are never going to engage in the sale of your company and get a price that's higher, even if the Q of E justifies it, than what's stated in the letter of intent.
Right.
The only direction that the purchase price is going to go is down, and everything that's done after the LOI is signed is either intended to validate that the purchase price can stay where it is, or it's intended to get the buyer a better deal. Now, I
Right.
understand that sounds like a cynical proposition, but I think it's important for us to also acknowledge the fact that doing deals is a game. And the object of the game is to pay as little as possible to get as much as possible. That's the buyer's objective. Even if they really like you, even if they really need you, they're going to try to get the best deal that they can. So your question was about pitfalls. I'll answer where buyers commonly find reason to adjust the purchase price. The first is financial, right? If you are accounting for the results and performance of your business using an accountant that you really like, who's giving you a very favorable tax position that is highly aggressive so that you pay less income tax, your financial statements are neither compiled nor audited, you can bet that the buyer is going to look at your results and performance in a very different way and probably get a very different number than you did when they applied their standard of accounting, which will typically be applied by a top 4 accounting firm if you're working with a private equity firm, or a top 8 accounting firm, so a very sophisticated party on the other side. That's the first issue we always see, and that's not even a legal issue. The next big issue we see has to do with organizational documents and contracts. Whatever your business is, the most of the value in your business is not in tangible personal property or real property. It's in the intangibles.
Right.
And in the intangibles, the most significant intangible that a business owns is its agreements. Most business owners have an understanding of what the broad body of contracts within their company is. They could say, yeah, we have an agreement for this, or yeah, we have an agreement for that. But most business owners do not know what those agreements actually say or actually mean in the eyes of a trained lawyer. You are not going to have a lawyer on either the sell side or the buy side looking at your agreements with any degree of grace. We're looking, quite honestly, for a standard of perfection. We're looking for the documents to be incredibly well drafted, to spell out the rights and responsibilities of the party. We're looking for agreements to be assignable. We're looking for agreements to be complete. If it's a stock sale, or even if it isn't a stock sale, if it's a corporation, we're looking for there to be shareholder agreements and stock certificates in place. Without these things in place, there's no way to secure the value or even prove ownership of the things that you claim to own at the time of sale. I wouldn't say that these are deal killers, but these are legal pitfalls, and these are issues in every single deal.
Yeah.
I've had one quick war story. I had a client come, a technology company, that was providing a solution to the market, and the purchase price for this transaction was $40 million. They maintained $20 million in software licenses with a very large software vendor that they had specifically negotiated and worked with over the course of time. They did not hire a lawyer to negotiate their agreements. When it came time to sell their company, they could not assign the $20 million in software licenses that were necessary to operate their business. That killed the deal.
So done. Didn't come
Done.
back to life.
Done.
Done.
Had we known that 3 years out, 5 years out, 18 months out, we could have identified the problem and at least encouraged them not to go to market or to begin working with the vendor that they had not
Yeah.
that they had been in a relationship with for a long time, and maybe given them a pathway to exit. But we didn't have that opportunity because they were in the middle of an auction, and we actually had exchanged drafts of a purchase agreement. I mean, we were doing the deal, and it just died overnight due to something like that.
Yeah.
I've seen environmental issues come up. Now, environmental issues shouldn't kill deals, but it depends on the dirt, right? And you can be held liable for environmental issues on land even if you don't own it. If you're just leasing it and using it, the environmental laws say that you have liability for what happens on the dirt, in the dirt, behind the dirt. It doesn't mean that you're pouring barrels of chemicals out back. If you're dumping, if you're putting things into the air, even if it's permitted, but you don't have the proper air permits. There's all kinds of weird regulations. Data privacy and security is becoming a bigger issue. There's a laundry list, John, of all the things that people that do this work every day on the legal side know can be issues that crop up in deals like this. And most business owners would say, that doesn't even touch my business. And I would say, more often than not, it touches your business in ways in which you don't appreciate.
Yeah. And those are all great points. I'm a little scared. If I'm listening to this, I'm thinking, oh crap, I can't get a deal done because I haven't done the work. So, let's take a step back and also, a lot of folks don't have, most of my clients, when we're going through the due diligence checklist, don't have their board minutes. They haven't even had board meetings. Those are things that someone like you can overcome.
Right.
But I think what we're getting at here, and I didn't like the example of the software company, but it's heartbreaking. But at the same time, that's an issue that could have been identified.
Yes.
And that is a deal killer. So
yes,
very few of my clients have engaged an M&A specific attorney to do pre-work before they go to.
Right.
Deals still get done,
of course,
but you're not in control.
Of course,
you've got blind spots.
Of course,
right? And that software example is a great one. So I actually want to go back to something that I probably should have asked you earlier. When we worked together, I introduced you to the client, and you went through a diligent process where you understood or tried to understand his motivations. And most attorneys, most M&A advisors are, hey, hire me, I want to do the work. And they don't spend much time doing diligence on the client to see if they can work together. Talk to me a little bit about that process and why it's so important. I was fascinated by it. I thought it was
fair.
Yeah.
So being a former military guy, and you'll just have to pardon the military analogies, I told you I didn't want to do anything contentious. And yet, given the fact that I was a former infantry officer, I guess I was drawn to M&A, and I learned very quickly that a good deal is a lot like a good trial. There is no less advocacy, there is no less tension, there is no less emotion involved in buying or selling a business as there is in litigating a significant dispute involving your business. So I do think about these things in terms of when a private equity firm shows up to buy your company and you sign a letter of intent and the data room is established and the diligence checklist is issued and we start working on a timeline, especially if we are in a competitive auction process like you would run.
Yeah.
We are in the equivalent of, I'm going to call it war.
You can do that as a veteran. I can't.
And I can do that. I can do that, right? But nobody's shooting at us, and yet that we are now against a clock.
Right.
The purchase price is going to go down. Everybody's rights are at risk. The buyer wants to see their side win, meaning they want to get the best deal that they can. I want to see my guy get a fair deal. I'm not going to get the best deal that I can and overpower a private equity firm. That's just not what we see on the sell side. My job is to help my clients get a fair deal. So when I'm screening my clients and meeting with them, at the beginning of these engagements, I want to understand what it's going to be like to be in the foxhole with them.
Yeah.
When these guys start shooting at us, when they start poking holes in your business, when they call your baby ugly,
Right.
when they discover the stuff inside of your company that you don't think is problematic, that now makes you feel very vulnerable to have exposed, how are you going to react? What is your emotional temperature? Are you going to turn on me? Are you going to turn on yourself? When the going gets tough, will you rise to the occasion? Or will you cower in fear and give the other side everything that they want because you're afraid that they'll walk away from the deal? What I look for in business owners, John, is not perfection. I look for coachability and teachability because I'm having to teach and coach my clients how we do this as we're doing it. It's all OJT. We're training with live ammunition. It's like having no basic training and saying, "You're going to war, baby, let's go." And we're fighting alongside each other. So I'm having to train and teach them as we go, but I'm also having to lead them. And that oftentimes means I'm asking and encouraging them to do things that are very difficult emotionally.
Yeah.
I understand what the buyer's toolbox is. I understand the framework in which he or she must operate. And I know where the buyer can accept and assume risk. And I know when the seller is being asked to do too much.
Yeah.
The seller has leverage in a business deal, but the leverage is only as good as your willingness to assert it. And quite honestly, if your seller is not willing to exert leverage in their own favor to take up for themselves, I know that what's coming next is the private equity firm or the strategic buyer on the other side is just going to take advantage of us all day.
Yeah.
And in the end, your thing is you want your clients to sell without regret. Those are the decisions that our clients regret the most. Where they compromised in deals because they felt fear, there was overwhelming emotion, so they compromised and they gave on something. And when the dust settles and the emotion clears and we're done toasting champagne glasses, they're now stuck with the deal that they have. That's where they have regret. So I'm not analyzing people's character, but I am trying to figure out, will they trust me to help them do things that are challenging for them? The mission of our firm is to help good people do difficult things with integrity and trust. I'm analyzing people to see if they're good.
Yeah.
Will they trust me? Will they act with integrity and not compromise themselves so that they can get the best outcome that they will be happy with years from now?
Yeah.
It's always a fight, but it's always worth it.
Yeah, that was magic right there. We're going to get our podcast editor to clip that part because that you hit the nail on the head. There are oftentimes clients come to us, they've got the offer, they've got, an LOI unsolicited. They haven't run a process. And these are professional buyers.
Right.
It gets hard
Of
to
course.
get a good deal done. And without the right team, without the right mentality, and listen, we want a fair deal. We like you said, we're not going to win on every point. We've got to give on some things. You can't negotiate all the risk out of a transaction. But it does take a lot of patience and hard work to get there. And the buyer's model, they're professional buyers, is to wear you down.
That's right.
Wear you down.
That's right.
Give you in, and then you give in, and you regret the deal.
That's right.
So
That's right.
I appreciated that. That was something new to me because I sat on that call with our mutual client, and I thought, oh, this is great, and I mean that. Everybody has their own style.
Right.
Yours worked, and I appreciate it, which is why you're my first lawyer on the How to Raise It podcast.
Thank you.
But so let's go back to educating the public on business owners on what to expect. These are not real estate transactions. When you sell your house, you walk away from most all liability.
Right.
You sell your mortgage and you're gone. It's not the same thing here in a business transaction. So would you mind talking through some legal concepts like reps and warranties, post-closing obligations, indemnifications, just educate the market on what that means, that you're going to have something left hanging over your head.
That's right. So we start with the idea that the person who knows the most about the business in a business transaction is the seller. If you're selling to a private equity firm or strategic buyer, professional buyer of any kind, they're actually going to know more about that business than the seller did at the time that it was sold. However, they're always going to shift the risk to the seller to have told the truth about the business because, at least in theory, that seller should have known everything about the business that the buyer needed to know so that they could achieve the same success and results as the seller did during the buyer's ownership period. So the bulk of a purchase agreement, the bulk of a deal, is not the financial terms. Most of the words on the piece of paper are representations and warranties about this business. Who owns the business? You certify that you do. Tell us about the financial statements. You've accounted for the results and performance in this way. Confirm your ownership of the assets. Tell us about your employees. Tell us about environmental exposure. Show us all of your IP. List all of your contracts. The bulk of a deal is understanding what the business is, where the value is, and how it gets transferred. And that is done in the middle of the purchase agreement, typically section 3 or 4. And it's the seller's representations and warranties. It's the buyer's representations and warranties. Appended to the back of the purchase agreement is not an insignificant document. It's a fairly significant document called disclosure schedule. So you use the analogy of selling your home. When you are listing your home for sale, you complete a seller's disclosure form. Do you have any mold issues? Does your property have any water runoff issues? Do you have polybutylene piping? Do you live in a flood zone? You have to say all these things about your house so that prospective acquirers can know. In the business context, you don't do that up front. You don't know what the buyer wants you to certify about your business until you receive a copy of the purchase agreement and you begin working on the disclosure schedules. But to the point that you were making a moment ago, as soon as that purchase agreement is signed, typically at the closing, as soon as those disclosure schedules are complete and you've told the buyer everything that it is that you're supposed to tell him or her, you're now on the hook after the closing for the truth of what you said. With that said, our policy, if you work with us, is honesty is the best policy. There is not a sophisticated buyer out there who is not going to figure out something that's wrong with your business. And you've had some other clients that you've worked with, even that have run into some trouble here, right? You can cut corners. You can say, yeah, we think this is okay, and not really check it out. But if you say that something is okay and you don't actually have your own legal team verify that it's okay, then you're really not sure, and that represents post-closing exposure. So there's this concept under a purchase agreement that says, if we figure out that something that you told us under the purchase agreement is different after the closing, and we have to come out of pocket to repair it, fix it, account for it, because it wasn't worked into our financial model, then whatever out-of-pocket losses or damages that we suffer, and in some cases, they're going to argue that their lost profits even should be accounted for as damages, we're going to come back and ask you for that money back. So it's not uncommon for a sophisticated buyer to ask the seller to escrow 10% of the purchase price at closing, or to acquire representation and warranty insurance, which would cover a breach of irreparable warranty, but would also necessitate the payment of additional cash at closing to put an insurance policy in place. The collective effect of which is to lower the amount of cash that the seller is going to get. And that's what sellers want the most, right? Seller wants to know, hey, how much money am I going to walk away with? Well, here's your top line purchase price, which assumes a normalized amount of working capital that you haven't yet delivered. So that can increase or decrease at the closing. Plus, you got to take out an indemnity escrow. Maybe there's an earnout that's included in that top line purchase price, but you haven't earned it yet. Even if there's a seller note, that's not money that goes in your bank account as of closing. And then you got to pay that big tax bill. So when you start doing the math here, net, you might walk away with half the actual cash value of your company at closing. If you have any debt that's got to be paid off at closing, that's going to be deducted from purchase price. My expenses, your fee, all your transaction expenses get taken out. There's a lot of money that gets deducted from that top line purchase price. What you don't want to happen is you don't want to subject yourself to post-closing liability where the buyer can actually reach into your bank account and claw money back because you misrepresented yourself even unintentionally.
Yeah. And thank you for that. This is one of those common issues I see in deals that are unrepresented or they don't have a team.
Right.
So let's talk just briefly, and I know it depends. It depends on each individual deal, but what are those limits? So let's say in your $40 million example, I know that business didn't close, but let's say there was fraud or they didn't own the business. What's the limit of liability? And then as you're answering that, maybe talk a little bit about caps and baskets too for those
Yeah.
non-fundamental reps. I don't mean to put you on the
No,
spot,
no, no,
but
no. Happy to do it. So, okay. I never want my client to sell their company with financial exposure in excess of what they were paid to sell it. So if you come to me and buy my company for $40 million and you find $50 million worth of issues, I'm going to say the most I'm going to pay you back is the money that you paid me. I'm not coming $10 million out of pocket to pay you for buying my company.
well, time out. I don't mean to interrupt you. Listeners are baffled right now. What do you mean they can come back after me? Right?
Yes.
So, and I know you're going to get there, but this is something that's so important for people to understand is that,
Right.
again, in the real estate transaction, there is post-closing liability. And if you don't have your diligence house in order, you haven't done your legal diligence,
Right.
financial and operational diligence well in advance, you're exposed. I didn't mean to interrupt you, but
No.
it's an important concept that we're constantly educating the market on.
That's right. And I've never seen this. Let's be
Yeah.
clear. This is legal theory, but it wouldn't be theory if there wasn't a practical application. If somebody hadn't sued somebody for damages in excess of the amount that they paid to acquire a business, we wouldn't have case law about this and we wouldn't even weave these legal concepts into business deals. But these concepts are woven into every business deal. So on the smaller deals in particular, we want to see a purchase price cap in respect of liability related to selling the business, unless we've committed fraud.
So those are fundamental reps.
Well, no, these are all reps.
Okay.
All reps, right? Even fundamental. I want to see a purchase price cap in
Got
the
it.
deal. So what you're saying, and let's give everybody the benefit of understanding the distinctions here, right? So a standard representation and warranty would be: here's all my intellectual property. Here's all my material contracts. Here's my employee census. Here's my top 10 customers and my top 10 suppliers. These are standard reps and warranties. But then there are some reps and warranties that are so fundamental. They speak to the heart of the deal. That if these representations and warranties aren't true, then it's a big problem for the buyer.
Right.
We typically see this in a stock deal. It would be, I own all the stock, or here is a capitalization table that shows all the shareholders. This is all of the issued and outstanding stock. There are no other shareholders. If that proves to be untrue after the closing and a shareholder got forgotten and didn't get paid at the closing, that's a really big problem. So that would be a fundamental rep. If it's an asset deal, or even if it's a stock deal, if for some reason the assets used in the business aren't actually owned by the business after you've represented that they were, that's a huge problem. That goes to the heart of the deal. So that would be a fundamental rep. Right. Sometimes we see environmental issues or environmental reps included in fundamentals. Sometimes we see ERISA liability and employee benefit liability included in fundamentals. Sometimes tax liability gets included in fundamentals. The reason why is because the government has the ability to claim against not only the buyer, but also, not only the seller, but also the buyer in respect of these types of claims. And the buyer's not off the hook. If you have environmental issues on your land that you just acquired from the seller, the government doesn't care. They're coming after you, and you have to go after the seller for indemnity as a result of that. So we call those fundamentals, and fundamental reps are treated differently under the indemnity rubric in a purchase agreement. We don't typically apply baskets and caps to fundamental reps. So one of the things we'll say in a purchase agreement is we're going to cap the liability related to the breach of standard reps at 10% of the purchase price or 25% of the purchase price. If I can get that from my client, that's a pretty good deal.
Yeah.
The purchase price cap on the overall liability of the deal would apply to fundamentals and standard reps.
Gotcha.
Okay.
Yep.
in the case of fraud, and this is always the case, right? Fraud means I I know something that you don't know, and I'm either telling you something that I know to be inaccurate or I'm failing to tell you something that I know to be true. And I'm hoping that you won't catch it, so I'm willfully and intentionally deceiving you. You rely on my deception, you pay me money, and you later discover my fraud. That we can't say that your intention to deceive the buyer should be limited by any limitations. So we typically see fraud as an exception to a purchase price cap under a purchase agreement. So that would be one of the
Yeah.
exceptions.
No, that makes sense, and it's interesting because working together on our deal, um, that was something you spent some time on, negotiating the
Right.
definition of fraud,
That's right.
and you just explained why it's so important.
That's right.
Um, and candidly, that's not something I would have thought to do. That's not something our client would have thought to do, but it was
Yeah.
important.
Well, and this is maybe going to your point a moment ago. Not every M&A attorney is created equally. A lot of M&A attorneys don't understand that you need to negotiate the definition of fraud because common law fraud under the Delaware definition, under Delaware case law, is very different than what might be the statutory definition of fraud in Georgia, for example. So it seems like a stupid little point that we spend a lot of time negotiating with the lawyers on the other side, except we're limiting the cause of action that can actually be claimed against our client. In the state of Delaware, if you accidentally leave something out, we call that a negligent omission, that could be construed as common law fraud. That's not what we're talking about. That's not what we're thinking about. That was negligence. That was accidental. That was an
Right.
oversight. It wasn't an intent to deceive. So we want to keep fraud in a very narrow definition of fraud for very good reasons.
I like it.
Yeah.
And that's where, oftentimes we're worrying about things that are very are unlikely to happen,
That's right.
right? But if they do, thank God that's been covered.
Well, and here's what I would like to say. From 2015 to 2022, I said this is the last good year to sell your company. And honestly, in 2023, that became our reality. The operating reality in terms of deal work, 2023 and 2024, deal work was slow.
Yeah.
It was down. We still did a bunch of deals, but they weren't as good as the deal market between 2015 and 2022. We are absolutely in a buyer's market. The deal terms have shifted. Buyers are going to be more aggressive in their terms, and if the buyer suffers any kind of loss because of the economic uncertainty of the current times, they're going to be more aggressive in pursuing these claims. So the stuff that we're talking about, pre-deal due diligence, being honest in your due diligence, having good reps and warranties, having fulsome disclosure schedules, negotiating tightly your indemnity, it's becoming even more important now in the current environment than it ever has been, at least than it was before. Why? Because when things are going well, nobody cares. If we're making money, nobody cares. The problem is we don't know what the markets hold. Is it a good time to sell? Absolutely. It's a better time to sell today than it will be in 2026, than it will be in 2030, than it will be in 2035. We see ourselves experiencing a market contraction, which creates a lot of opportunity for business buyers and business sellers, I think, over the next 5 years. But terms are going to become more aggressive, and the approach that you take to selling in terms of protecting yourself after the close become even more important.
Right. So, Rob, we've got buyers approaching sellers. We've got folks who are not really taking control of the process. I guess the question I have for you is you represent all kinds of different owners and businesses, those
Right.
who have received an unsolicited offer, those who are represented by someone like me. Kind of talk through the dynamic there, what you see as how is your role different when you have someone like me on the other side versus
Yeah.
not? Just kind of talk through the importance of a team from your standpoint.
I'll give you an example that's happening right now for us. and it's not with you, but we had a client referred to us last year. They had received a couple unsolicited offers. They were considering those offers carefully. They hadn't engaged an M&A advisor. They work with a pretty good accountant. We didn't know him. And we began to consider those offers, but quite honestly, there wasn't a true understanding of what the business was worth. And my sense, just on the basis of this particular industry vertical, was that the client could probably get a better deal if they were to hire an M&A advisor and go to market. The client agreed with that. In fact, the client knew another business owner in the space who had worked with an investment bank that specializes in this particular industry vertical, and they had a good outcome. So the client retained us to help them evaluate their current unsolicited offers, and ultimately decided to put those offers on hold, not cut them off altogether. But they engaged an M&A advisor, and we helped them with that. So I've never had this relationship with you, but I think it's helpful for the listening audience to say you need to look at and negotiate the arrangement with someone like you. The M&A advisors are not all created equally. And I've had clients come to me with an M&A advisor, and they signed an agreement that I thought a more sophisticated client might not have signed that had they understood it. That's not something that I would worry about in an engagement with you. But there are many M&A advisors out there who are soliciting our clients and saying, hey, I would like to help you see what your company is worth for a specific amount of money. I will put together a book and I'll take you to market. If you just sign this engagement letter here, it just costs you $30,000 for me to put together a book and take it to market so we can see what the company's worth. The problem with that is there's a success fee tied to that. When you see that your company's worth more than you thought it was, and you let those folks take you to market, there's a success fee tied to that transaction that you probably wouldn't have paid somebody like you, because you wouldn't have asked for that kind of fee, because you wouldn't have even engaged in that kind of approach. So I don't want to speak against your industry, but there are larger operations out there that are trying to get deal volume, and they're using that kind of approach. So I would say to clients, don't even sign an M&A advisor engagement letter until you've had that reviewed by somebody who can help you. My client did that. They hired a transaction advisory firm to do a sell-side QV. Not all clients do that. When you do a sell-side QV, and you know this, John, and that's another advisor that you're going to have to spend money for. But when
that's not based on a success fee. That's cash out of your pocket.
And that's not you. You don't do QVs. I don't do QVs, but we love a good, sophisticated financial advisor that can do quality of earnings, working capital analysis, purchase price allocation. They can help with all that kind of stuff. So having those folks on the team is imperative, I think, to the success of the deal. My client hired a QOV provider. They got a QOV. They did a great job. The purchase price that was being offered to our client when they were receiving unsolicited offers was I don't want to say the purchase price, but I'll say it this way. After they hired the M&A advisor, after they did the sell-side QOV, we just signed an LOI, and the purchase price that's now being offered to them is 40% higher than what they were receiving in their unsolicited offers. Whatever fee they're paying their M&A advisor, the M&A advisor not only paid for their fee, but they are going to pay for generations of my client's grandchildren, maybe to go to college or do whatever they're going to do with their wealth. You cannot overstate the importance of knowing the right advisors trusting those advisors to help you build a
Yeah.
team, retaining that team, and here's the most important part, trusting what they say.
Yeah.
There's no conflict of interest in respect of the parties that you hire to help you sell your company. They're going to get their fee.
Yeah.
And they all want a great outcome. The incentives are all aligned. What my experience is, if you're willing to trust the process and you hire the right advisors, any out-of-pocket expense that you incur is an investment in the success of your transaction for which a return comes significantly.
Yeah. No, I think that's spot on. The other thing, there's a lot of nuggets there that I'll touch on, but one of those is your team doesn't always have to get along. Now, they have to treat each other with respect, but even in our deal, we had disagreements on approaches, but we were professional, we got them done, and we ultimately got a good deal done. So I think that, team members bringing different lenses or different viewpoints is actually very important.
That's right.
As long as they're doing what's in the best interest of the client, of course. And let's just talk a little bit about M&A advisor success fees and structures, because you brought it up, and I think it's important for folks to be aware of it. There are big firms out there who do charge a ton of money to develop the book and do evaluation. Our firm and many others out there will do a complimentary opinion of value, showing what the business is worth.
Yeah.
And once we're ready to go to market, we'll charge a development fee between $5,000 and $10,000. That's it. Everything else is success fee based. We used to not charge that development fee because we wanted to say we're aligned with your success, and we want to be sure that we're not getting paid unless you're getting paid. Ultimately, we have to have some gauge to make sure that our clients are serious about the process and it covers our costs. So from our standpoint, cash equals commitment, but it's not $35,000 or $45,000 or $55,000.
Yeah.
It's $5,000. And, I've got a prospect now who I'm speaking with who's got his attorney reviewing one of those engagement letters because he got no offers, nothing other than a valuation and a pre-PowerPoint, right? That's an important part of the process, but that's not worth, that kind of money, nor is it worth the tail that you sign up for. So some of those firms will give you a list of prospective buyers and say, here's who we're going after, and we're protected for a period of time, whether it's 18, 24 months, I've seen longer.
That's right.
So any of these buyers,
That's right.
regardless of whether or not they were approached by this firm, a good M&A advisor
That's right.
is going to put some caveat there that says, hey, the tail period only applies if they've signed the non-disclosure agreement, not because I gave you a list, right? So it really does bug me when I see folks who've signed and really are ready to exit their business. They've got a sellable asset, but they're handcuffed by some advisor who didn't have their best interests in mind. So our firm was set up to address that. Others are set up to address that. There are good ones out there, right? But I cringe when someone is considering hiring one of those firms and writing a big check because the results don't often align with.
I'm dealing with one right now.
Yeah. And it's hard to get out of, isn't it?
It's incredibly hard to get out of, especially when you agree to pay on a 3-year tail for any deal that you do.
3 years. Wow.
Any deal you do.
Yeah. So there's no caveat. It's any deal you do.
Any deal you do, even if we didn't introduce.
Yeah. So let's talk about that as well, because that's heartbreaking. That's handcuffing someone.
It's atrocious.
We have an exclusive agreement, 12 months. But after our agreement expires, it's no longer exclusive.
Yeah.
It's only for those people who've engaged with us and been part of our process. So I wish there was a way to combat that, because a lot of those firms have a lot of money to spend on marketing.
That's right.
And they do a good job of marketing to sign up clients. They do a really bad job of selling businesses.
That's right.
So anyway, not trying to get too worked up on the power exit.
No, but these are important distinctions. Again, do your homework.
Yeah.
Don't hire somebody because, check them out. If somebody else referred them to you, check them out.
Yeah.
But a good M&A advisor will say, here's what you should be looking for in people like me. And I will tell this to people who are hiring me. I will sit down and say, listen, even if you don't hire me, hire somebody like me and make sure that these are the things that they're going to do for you.
Right.
because I want them to succeed,
Right.
even if they don't use me. And I think that's important. There's a broader ecosystem here that we're trying to improve. And ultimately, the client has to win. We want to see business owners thrive. You know the statistics. Business owner satisfaction after an exit, those statistics are way too low, which is why we're engaged in this collective body of work to improve those statistics and not just get people a great outcome, but give them a good experience. We want them to have an experience that they say, that was hard, but it wasn't the worst thing that I've ever done. And I never want to talk to those people ever again. That's not the experience that our clients have.
No, and it's important. I feel, and we share some values that we're here to serve.
Right.
We're very lucky that we can afford to take our kids on vacation and hopefully retire one day. But we're here to serve people, and
That's right.
I'm thrilled that you and I are in our network. We're in each other's networks. We need to do more deals together.
Yeah.
But yeah, 23 was a slower year for our firm. It was still a great year,
Sure.
but we saw that,
That's right.
which is important to know, because if the market's a little slower, you can still be preparing for a sale. You can still
That's the
be
best
getting
time
ready.
to prepare.
That's right. That's when you hire, Rob.
That's
And
right.
you do,
That's right.
you look at these contracts. You look at it. I'll give you an example. We've got a business. We're doing the due diligence kickoff today. It's an HVAC company. And the buyer asked me about the assignment clauses in the contract. I've read them. I'm not an attorney. I said, here they are. Here's my view on them with the disclaimer that I am not an attorney. And that client didn't choose to engage an attorney pre-LOI, and that's actually something we were about to wrap up here, but there's something I didn't ask you that I wanted to go through. So sorry for the hard switch here, but you and others are pretty adamant that I don't want that I need to review the LOI at that stage at the latest point, right?
Yeah.
Why is that?
Okay.
It's a softball question.
You asking me to help you just get it done, meaning, hey, I got this LOI. I just need your help just
Yeah.
closing this deal. I would tell you that you've taken my ability to add value to your transaction. You've reduced it by about 75%. And you've communicated to the buyer that you're probably afraid, definitely unsophisticated, and 3, probably going to give the buyer everything that they want.
Yeah. Yeah.
So to hire somebody like me who's trained and whose heart's desire is to give you an exceptional outcome against the backdrop of, I've already given away all my leverage. I didn't trust anybody to help me. And I've already communicated to the buyer that whatever they want, I'm probably going to give them. You don't need me. You can hire with all due respect, any lawyer to help you just close a deal. But you're not going to be satisfied with that outcome. And I guess I could help you do it. But you've really kind of tied my hands and bound my feet and gagged me and said, hey, I really want you to do your best to help me. And I'm like, well, then why did you limit all of my ability by signing a document that gave away all your leverage? Once you sign an LOI, the deal terms don't get better. And nobody has ever drafted an LOI that the seller should just take one glance at and say, well, that's exactly the deal I'm going to do. A really good private equity firm, even one that's really interested in your company, is going to give you an attractive LOI.
Yeah.
But they're not going to give you all the terms that they need to give you to make sure that you've got a fully fleshed out deal that frames up the deal and shapes it for the attorneys who are going to come in and put the purchase agreement and all these other documents together. If you don't flesh that stuff out at the LOI, there's a chance your deal could die because there's a huge miscommunication about an uncommunicated point.
Yeah.
Or you're going to get terms that are either not addressed in the LOI or ambiguous in the LOI. And you're later going to realize you now have to deal with those terms because you didn't raise them at the time that you had the ability to.
Yeah.
So rarely will I work with a client who has signed an LOI. It's just, with all due respect to clients, it's never in your best interest to sign even a confidentiality agreement,
Agreed.
quite honestly,
Agreed.
without having someone review that for you.
So it's a common tactic for these private equity firms to push back and say, hey, your attorney's being very difficult on this LOI. Oh, you don't need to engage an attorney to review this LOI. Even these private equity firms with billions of dollars under management will push back on me and say, oh, you're involving an attorney at this stage of the process? And my response is absolutely yes.
Right.
It is important, and I won't work with a client, or I will not advise a client to sign an LOI without having an attorney. A lot of times they're hesitant to build a team early enough. When they engage me, I'm making introductions to folks like you, financial advisors, CPAs if we need it, sell-side quality earnings firms. But they see it as, oh, let's let John really do his job to see if there's a deal before I start spending money and time on those advisors, which is a mistake. But absolutely at the LOI stage, does someone need to sign it?
It's going to cost you $500, $1,000 to get a confidentiality agreement in place. It's going to cost you $2,500 to get an LOI done.
Yeah.
That's it.
Yeah.
If you're working with me.
Yeah.
And that is those two documents are all that you have until you sign a purchase agreement at the closing.
Yeah.
Why wouldn't you make that investment?
Yeah.
It's just not wise.
It is foolish. And I think there's, me included as a business owner, there's a little bit of a gunslinger. I can make this happen. I've done this. I've built this, but I don't need to spend the money on that stuff. This is not the time. You've got to get out of that mentality.
Right. And that goes back to my original comment, which is I speak deal with all due respect. Please trust me to help you. This is important. You want this.
Well, Rob, I'm thrilled that you joined me here.
Thank you.
I'm excited to see you again, hopefully to work on some future deals. But, Tim Ferriss, not that I'm comparing my podcast to Tim Ferriss, but he has a great line where he says, if you had a billboard and you were going to put something on the billboard, what would it be for you if the audience is only business owners who are going to exit in the next 3 to 5 years? What would your billboard say?
Act now. Choose wisely.
I like it. And I didn't even prep you with that on the questions. You nailed it. So, Rob, thank you for being here. How can we get in touch with you if we want to reach out?
We've got a website, www.conciliumls.com. You can just Google me, Rob Swartwood. Phone number, email, all that's available. Would love to hear from anybody. Connect with us on LinkedIn, whatever.
Awesome.
Call
Rob,
John.
thanks so much. Yeah,
Thank
absolutely,
you.
buddy.